The Albany County Family Court is a specialized court for children designed to promote rehabilitation of youths.
Okay, Jason and his father, please come into Judge Mandy's courtroom. Anybody else that's involved?
It is concerned with acting both in the best interest of the child and in the best interest of public protection. Family courts have broad jurisdiction over a wide range of personal and household problems, including delinquency, paternity, child support, and custody issues. The family court handles most cases involving youths between the ages of 7 and 16 who are charged with offenses that would be crimes if committed by adults. Persons under the age of 18 may be considered PINs, or persons in need of supervision. Depending upon the offense, some may be considered juvenile delinquents. Each person involved in the family court process has an important role. The law guardian represents children in juvenile court and plays an active role in all stages of proceedings. The law guardian is a lawyer assigned by the judge to represent the child in a juvenile court case. The law guardian serves many roles. He or she serves as a legal advocate on the child's behalf and also works with parents and human service professionals in finding a proper treatment plan that serves the interests of the child. Although the law guardian is assigned by the judge, families are free to choose their own private attorney to represent their interests if they prefer.
Your Honor, I have no objection to the respondent being released to the care of her mother.
The county attorney is a government lawyer responsible for representing the interests of the people of Albany County.
It's my understanding that the county attorney and the law guardian are requesting adjournment. The court will grant that adjournment for the county attorney.
The judge is a lawyer with more than 10 years' experience who is elected by the voters of the county for a term of 10 years. The judge oversees the courtroom and makes sure that the juvenile matter progresses to resolution as quickly as possible. The judge advises the juvenile of his or her rights. The judge must listen to the evidence presented, apply the law to the facts in the case, and make a final decision that is in the best interest of the juvenile. A representative from the Department of Probation prepares reports for the judges about the people involved in the cases.
There will be additional special conditions to the probation. They will be
the respondent is the juvenile against whom a petition is filed.
Judge, at this time, my client is prepared to waive her right to a fact-finding hearing and to enter an admission to one of the allegations contained in the petition.
A representative from the Department of Children, Youth, and Families is present to provide information to the judge if needed for detention placement or placement referrals to such things as residential placement facilities.
Hey, Jason and your father, come on in Judge Mandy's courtroom, please.
Present also is the sheriff's staff. These are uniformed court attendants who are assigned to every courtroom and hearing room. The court attendant is the person the respondent checks in with upon arrival.
Step out of cell, please.
The sheriff's department provides security throughout the building and also calls the parties into the hearing rooms when the judge is ready to hear each case.
Your Honor, we feel like that she needs some more supervision. She doesn't listen at home. We've tried everything.
Family members are also often present in court to support and present information to assist the judge in making a decision in the best interest of the child. As these members of the process gather, they are expected to comply with courtroom standards. Dress does not have to be formal. A plain, neat appearance is good. Don't wear a hat, do not chew gum, and do not bring your cell phone or iPod into court. You are of course expected to tell the truth. Respondents should speak up, give firm answers, and maintain good eye contact with whom he or she is speaking. The petition is a formal complaint filed by the county attorney charging the juvenile with either a PINS or a JD. A PINS offense is an act that is only illegal for juveniles, such as running away from home, truancy, possession of alcohol, curfew violations, and ungovernable behavior at home. The petition on a PINS is filed by the parent or school district with prior approval of the probation department. Juvenile delinquency is a violation of a criminal law that would be a crime if the act were committed by an adult. Common examples include theft, burglary, sale or possession of drugs, and criminal damages to property.
Now, I have to advise you of your rights. You have a right to remain silent. You have a right to an attorney. You have a right to have a trial or a hearing on this matter.
Once the petition is filed, a court date is set for arraignment. The person is also informed of constitutional rights. These include the right to remain silent, the right to an attorney, and the right to have a hearing. A hearing is a proceeding that is similar to a trial in criminal court. After the juvenile is arraigned, the law guardian, after talking with the juvenile, will enter a general denial or admission to the petition. When a general denial is entered, the judge will order an adjournment for further discussion between the law guardian and the respondent, and the law guardian and the county attorney. A plea bargain permits the respondent to make an admission to a less serious charge. In either situation, the judge makes a decision regarding the release status of the juvenile. The judge will ask the county attorney and possibly others in court for a recommendation regarding release status.
Have the parties reached an agreement?
No agreement has been made at this time, Judge.
Then we'll set the matter down for...
Since the defense and prosecution did not come to an agreement through plea bargaining, the judge will adjourn and will set a date for further proceedings. A plea bargain can be reached at any time before the next court date. If there is no plea agreement, then the case goes to a hearing.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Be seated.
These hearings are much less formal than adult trials because there is no jury in the family court. All facts and witness testimony are stated.
Judge, at this time, my client is prepared to waive her right to have a fact-finding hearing and to enter an admission to one of the allegations contained in the petition. I would further ask that she be allowed to return home to the care of her mother.
Your Honor, I have no objection to the respondent being released to the care of her mother. However, if she's going to be released, we ask that she be placed on JRUS until return.
The case is adjourned again for disposition. A probation report gets ordered, and the judge again makes a determination on the release status of the juvenile. After the judge has heard both sides of the case and heard from the parents, he will recess the case until a later date, and they will return for the final disposition where the judge comes to a decision about the sentence of the juvenile.
And for the county attorney and the law guardian to discuss.
When they return to court with the probation report, the county attorney needs to agree, the respondent needs to agree, and the judge needs to agree. After the child has admitted to the allegations or the allegations were proved in the hearing, the judge normally orders the probation department to complete a predisposition report. The predisposition report, which is similar to the pre-sentence report in an adult court, has a number of purposes. It aids the probation officer in developing treatment programs when the child is in need of counseling or community supervision. And it can help the court develop information about the child that can aid others in treating the child. Sources of information for the disposition include family members and school officials who can speak about the juvenile, and at this hearing, statements can be made from the juvenile offenders themselves. And the judge discusses release status with the court attorney, law guardian, and parents. Most notably with JD cases, but certainly with PINS proceedings as well, one of the most important determinations a judge makes is the release status of the youth while the case progresses. The judge will consider input from various sources. The judge will carefully consider the behavior the youth has demonstrated, as well as the youth's likelihood to comply with the conditions the judge will order. The judge may release the youth to the supervision of his or her parents, often with special conditions, including supervision by probation or participation in programs designed to assist youth and families. If the judge feels the safety of the youth or others in the community will be in jeopardy if the youth is released, the judge will order the youth to be detained. In situations of higher risk, the detention could be in a secure facility. Throughout these options, the focus of the family court remains on rehabilitation and safety, and not punishment. For persons in need of supervision cases, where an investigation and report is ordered, the report generally addresses similar information, including nature of the offense, legal history, family and environment, school, community and peer relationships, alcohol and drugs, physical and mental health, employment, use of free time, attitudes, and behaviors.
There will be additional special conditions to the probation. They will be to stay away from the co-respondent, to do 30 hours of community service, which be arranged by the probation department, and to pay restitution to the victim within 6 months.
PINS and JD proceedings are intended to benefit not only the youth and families who appear in family court, but the entire community of Albany as well. But family court can be an overwhelming experience. It is often complex, and the actions taken may sometimes be difficult to understand. Nevertheless, it is important to ask questions when you have them, of a law guardian or caseworker, or even the judge. If you are not clear about an action of the court or what is expected of you, always ask. And unlike some courts, comments and information that come from the youth, families, and others who appear in family court all contribute significantly to the decisions that are made, so it is important to consider that it can really be the family court and you working together.